Plaintiff and defendants entered into a contract on November 15th of last year in which plaintiff agreed to construct a store building for defendants for the sum of $65,435. The contract further provides for the completion of the building by March 15th of this year, and in this connection contained a penalty and bonus clause to the effect that plaintiff would be liable to defendants for $125 per day for each working day the work remained uncompleted, and defendants would be liable to plaintiff for a similar amount for each working day that the building was completed and ahead of schedule. The building was not completed until 49 days after the date specified in the contract. Defendants contend the delay was due to inclement weather of which plaintiff was required to take the risk, together with plaintiff's incompetence. Plaintiff contends it was due to acts of the defendant. The court found that plaintiff did not fail to complete and work set forth in said contract, and change orders and extras for a total period of 49 work days, but for a period of 15 days and no more. The court, therefore, reduced the balance for plaintiff on the contract by $2,000. There were certain other offsets which the court allowed in reaching the balance due under the contract of $4,710.40. No challenge is made of this figure, except as it would be affected by a determination as urged by defendants that they should be allowed a credit of $125 per day for 49 days instead of for only 15 days as allowed. Ladies and gentlemen of the jury, you will consider all of the evidence in the case. Counsel, in arguing to you, of course, cannot go into all of the evidence. They argue to you on the basis of what they think is important and relevant and helpful to you in this case. The court will say very little about the evidence because you have heard it. This case has not been overlong. You have been attentive to all the proceedings, and counsel have summarized it quite well. We shall be brief in our charge, since we want you to understand what we are doing. It will not be an entire summary, but it is your obligation and duty to consider all the evidence in the case to arrive at your verdict. It marks specifically not only to motor vehicles, but to the operation of a bicycle on a highway. When a person operates a bicycle on the highway, then he has the duty and obligation, which I shall go into at greater length as I charge you. The law of Pennsylvania is that any person drawing a verdict on the highway shall drive the vehicle at a careful and prudent speed, not greater than nor less than reasonable and proper, having due regard to the traffic, surface of the highway, and any other restrictions and conditions then and there existing. No person shall drive any vehicle upon a highway at such speed as to endanger the life, limb, and property of any people. It is the law of Pennsylvania that the driver of an automobile must at all times have his vehicle under control. This means that a driver shall have his vehicle under such control that it can be stopped before doing injury to any person in any situation that is reasonably likely to arise under the circumstances. Now, it will be for you, of course, to determine what the circumstances were and what the ordinarily prudent person would have done under those circumstances. Your Honor, Mr. Corvallis, ladies and gentlemen of the jury, counsel has indicated to you on several occasions during the course of his closing that our criminal justice system affords the defendant an opportunity for a fair trial. He has indicated that it is something that is unique in our culture and to our country. The judge will instruct you on this site also, but there is a certain amount of unfairness which goes beyond the record. There is nothing that we as attorneys say that is evident in this case.